It worked, Isaac, this time. So I'm here to invite a friend and colleague, Isaac McBeth. Isaac is from Richmond, and a funny thing happened to me when I began to do expert witness work back in 2013. A friend of mine who I had not seen in about 50 years, maybe 40, from grade school. I had visited Richmond before from Rhode Island, where I was living as a child. And my friend from fifth grade moved down to Richmond, and he got in touch with me after around 50 years on Facebook. Shortly after that, Isaac contacted me about taking a case in Richmond, and I believe in serendipity. I really felt strongly about it that I should go ahead and take that case, and it might bring me to Richmond to visit with my friend, who we were very close friends in grade school. And as it turned out, I took that case. I never ended up having to appear in Richmond, but some years later, I did a survey for the National Commission at over there in Richmond, near Richmond. And I met in person with Isaac for the second time. I took that case. Isaac came to Oregon, where I was living at the time, and helped prep me for a deposition. And as I recall, that was settled, and we, like, more or less won the case. And the bottom line is that the race was on for me to take some cases, and that's what I did. But Isaac was the person who trained me in essentially in how to do a deposition without ruining the case, and I'm grateful to him for that. And I think that I didn't ruin the case. Isaac is still practicing in Richmond, does mostly, that was a defense case that I work with him on, does mostly plaintiff work these days. I think all plaintiff work. And I'm proud to be able to give this talk with him. And Isaac, you can introduce yourself some more, or introduce me some if you wish.
Well, thank you all so much for letting me be here to speak with you. Like Mike said, I practice out of Richmond. I've been doing correctional medicine cases basically since I graduated law school. And I've done it both plaintiff and defense, and I've handled big and small cases. And I've known Mike and worked with Mike for the last 10 years. And I'm very appreciative of the opportunity to speak with all of you. I don't know that there's a whole lot else that's remarkable about me, but I do a lot of this work, and I think it's very important.
I'm not going to read the objectives. I think you're capable of reading them, and that many of you have already seen these. We're going to do some cases first. I will also say that well, no, let's just do the cases. There's the biopics. We made them up. They're based on real cases, though, and they're simplified to make a point. So case number one, your ACCP colleague is a medical doctor. You've met him at the National Commission and at the ACCP conferences. He's at a mid-sized urban county jail, and he's hired to see patients 2 days a week over there. And his lawyer calls you and says that he's got a lawsuit, and that he specifically has asked you. This actually happened to me, which is pretty cool. I thought, wow, really? And then
with her legs.
Please mute. Ebony, whoever you are, please mute. We can hear you. So the basic case theory was that he never saw this patient. He was the medical director. He was called the medical director, and he's responsible for all the clinical care. And so therefore, the fact that he never met this patient doesn't matter. This case has been going on for 5 years, and it's hanging over his head the whole time. You can see that his contract does say that he's a medical director, but his only responsibilities contractually are that he sees patients twice a week and he's on call. The institution hires the nurses, not the nonprofit company he works for. So he
And they're
has
coming for her, right?
really no responsibility for the hiring or firing or training of nurses. And we don't know whether they were after the nurses. I was only on the case for the medical director, a friend of mine and colleague.
And he's a robot, right?
If Ebony Harris can stop talking and put the computer on mute, that would be so nice, please. So the patient died, but the defendant physician, my friend, had no contact with the patient, never met him, never saw him, had not his name in the chart at all, was not present or on call, but he was called the medical director, so he was named. And it actually took them 5 years to drop him off this case. And I don't know what the outcome was for any of the others. So the expert for the plaintiff family is an internist at the local medical school. And I say that that is also true. And so I made up some of this stuff, but that is also true. And so they did not even have a correctional doc on the case for the plaintiff. She had never worked in a correctional institution. And once in a while, she considers herself an expert in corrections because she sees individuals once in a while in the course of her clinical practice. So I'm willing, I guess for these, we can take comments now, but I'll just tell you that the outcome was that the case, of course, was dismissed against the person that I was defending, but it really helped that I came in and said, wait a minute, just because he's called a medical director, there are lots of medical directors in corrections who are not in charge of everything that happens in the institution. There are some that are, and we're actually working on a talk in these sessions along those lines. What are the responsibilities of a medical director, a site medical director, or a regional medical director? And we're working on that. So the case was dismissed. Any comments on that? I'm willing to take a comment or two. So the point is that we get sued a lot. Our colleagues are in no man's land for years with litigation hanging over their heads, and we're the ones who are best. We who work in a correctional facility are best suited as expert witnesses in correctional cases because of our esoteric knowledge. If there's no corrections expert on the case, other experts are definitely stepping in, and they don't know what they're talking about when it comes to corrections. They may be the top guy in hematology in the land, but they don't get corrections, and that's important because what we do is different from what goes on in every other milieu, in every other community setting. That's my opinion.
Dr. Perini?
Yes.
Quick question. So would it have made a difference if the person who was seeing the patient was a midlife, I'm sorry, not midwife, a nurse practitioner or a PA whose medical director is the supervisory physician?
So in most jurisdictions, that's a great question. And in most jurisdictions, and Isaac, I think, should be answering some of this, but in most jurisdictions, the nurse practitioners are allowed to be private practitioners and not have a supervising physician. But where I worked in Oregon, and in most places where I'm familiar with, physician assistants did need to have a supervising physician. And I think that you could be called on for that if you were the only doctor on site and would call the medical director. Isaac, do you have a comment on that?
Yeah, I mean, that's basically the answer that I would give. So for example, in Virginia, nurse practitioners and PAs are allowed to practice without the supervision of an MD. And a lot of the poor localities actually staff their medical director position with a PA. But interestingly enough, kind of in this case study, we also have very strict scope of practice regulations for LPNs in Virginia. And so, even if in the case of this medical director here, who wasn't interacting with these nursing staff or supervising them, that could possibly create complications as it relates to, well, somebody's got to be on the hook because In Virginia, LPNs have to be under the supervision of an RN or a provider. So there's, I guess the comment I'm making is there's very specific jurisdictional nuances to all of these types of dynamics on that question. It gets very state specific very quickly.
So anyway,
Can I ask a question too, please?
go ahead.
Are not the NCCHC guidelines suggesting that the physician has to be the site medical authority for the facility, or else none of this makes any sense? Or is that no longer true?
There has to be a doctor who's in charge, and I've forgotten the exact verbiage, and so there are nuances to this, as we said, but the bottom line was that this case was dismissed against this person in part because of a report that I wrote, because he was not contracted to do that, you know. And so they have I think the corporate had a regional medical director who was the responsible. I think the responsible health authority was the health services administrator, and the responsible physician was at corporate. So are there nuances to this? Absolutely. And can you get sucked into all those nuances? Yeah, as a physician, you need to be able to understand those nuances and talk the cases over carefully with your lawyer. So, but the point of this case is essentially we need talented medical providers who can serve as expert witnesses in these cases, because otherwise somebody else is going to step in and one of our colleagues could get squashed on irresponsibly. And so
Like
we're
one of the
looking
questions you got in the comments was this a federal deliberate indifference claim or a state med mal claim?
I've forgotten, and it doesn't matter, because I think that it would have been, you know, it must have been a DI case, a deliberate indifference case, because otherwise he absolutely couldn't be called on malpractice, because he never saw the patient, never consulted in the patient, the name didn't appear in the chart. So I think it would have been even more of a slam dunk if it were a malpractice. Don't you think, Isaac?
Yeah, I do.
So at any rate, let's get on to case number 2. It's a little bit more interesting. And this is a case that, can I say that, Isaac, that
Yep.
Isaac and I worked on. And I got an email about a case. He's a 30-year-old guy, and I made up all of this, okay? A 30-year-old guy, he got a mesenteric bowel infarction and a prolonged hospitalization, loss of bowel, loss of neurologic function, permanent short bowel syndrome, and permanent disability. It's a plaintiff case, and I'd worked with this lawyer before on a defense case, interestingly enough, and I decided that I'd take the case on for review because I've got this trust relationship with this lawyer. And the case interested me because it felt like, just on an initial read, my initial read talking the case over with the lawyer, it felt like the doctor didn't give a rip, and that this was a reasonable plaintiff case. I'm very careful about which plaintiff cases I'll take, and I trusted. I think that the moral of the story is, the most important moral of the story is that I trusted the lawyer that I was talking to. So anyway, this guy had Crohn's disease, he had GI bleeding, and a known documented intra-abdominal thrombosis, both at the same time. And he was treated through his illness on site, never going out to the emergency facility or to the hospital. He was refusing Coumadin, but was never offered any alternative treatment. They were available at the time. He had a known clot. He was refusing oral steroids. And he had reason for both these refusals, but they were never noted anywhere in the chart. And he was never offered an alternative treatment for his known Crohn's disease or his clot. And the theory is that the theory of the case, and this is an important thing to know, is an informed refusal was never done. the documentation was poor, and the treating physician really had this complex patient who was not receiving any meaningful treatment because he continued to offer the same refused treatment for months without consulting anybody from outside. And he didn't properly seek outside advice. And he finally became acutely ill. He was septic, he had a clot and lost bowel, and he gangrenous bowel, etc. And in this case, I'll tell you, the outcome was settled out outside of. Did we do like a, Isaac? I think this one actually came to trial, didn't it? It was a bench trial or something.
He
It wasn't a jury trial, and I know I never had to appear.
Yeah, he accepted to offer a judgment. So it was a formal judgment entered in the court against him without having to go to the trial.
So essentially, you won the case, and this guy got a monetary settlement. Am I on that right?
That's right.
Comments? That's a much more controversial case, isn't it?
Oh, yeah.
So my thoughts about the relevance of this case is that it keeps on answering the question, why do we need good correctional medicine expert witnesses? This was a non-compliant, non-adherent patient, and how many do we all have? And we understand the corrections dynamics. The patient doesn't choose us, we choose them. They don't choose us, we don't choose them. And we have to figure out how to work together regardless of that. And this dynamic of figuring out how to work with your patient and how to document your work with your patient was never documented in this chart. And I'll say that, and this is me trying to pat myself on the back, I think I was right in sniffing out the provider who was antagonistic toward this inmate, not patient, but inmate. And that's a judgment that, and when I'm reading a case, I'm just going to have to make. Some of the meds were formulary, and he was not offered anything off the formulary in any way, shape, or form during the course of his near fatal illness. He spent 35 days in the hospital, I think. So we get it. And that's the essential point. We get it why correctional medicine is different from community medicine, because we hold this as esoteric knowledge. And a lot of these cases are really complex. They're intellectually challenging. That's why I like doing them. I like being able to defend a doc who's doing right. I like to be able to defend a patient who's not getting proper care, and the intellectual challenge of it and the interpersonal dynamic of it is really, really, I like it a lot. So, and I can't tell you how many times I've learned really important information from these cases about practicing good clinical medicine and as importantly, about documentation. And these days I do a lot of consulting, and I bring a lot of these case things into my consulting work because I can see the same kind of documentation errors in the charts that I review, and I can warn them off of that and into a better way of documentation. And I think the last thing, I don't read my slides. I hope you folks all know how to read. But I think that it's still true that a lot of the progress in correctional medicine is happening through the court intervention. Isaac, I hope you have something to say about that.
Yeah, well, I think that, that's actually one of the, the justifications for being a plaintiff's expert. I mean, I know that there's undoubtedly hesitancy about perhaps staking a claim against one of your own, and I get it. I mean, I don't accept legal malpractice claims for the exact same reason. I'm very hesitant to criticize another lawyer, especially, someone who's down in the trenches doing hard work. But, unfortunately, I think that what we can observe is, despite the overwhelming majority of individuals in correctional medicine actually, being sincerely compassionate and caring providers, there are times where stagnation can set in, or the environment can desensitize certain individuals, and they sort of get anchored into these roles where they're perpetually providing care that just is it's honestly sometimes very hazardous. And so there is an element of this that sometimes litigation is needed to move care forward in certain localities or certain facilities, and there is a very patient sensitive purpose behind that. It's not just about money. There actually is very important clinical components to what happens.
Advancing the field.
Yeah.
And I'm just going to go briefly through the first call. Somebody said the way this happens almost all the time for me is I either get a phone call or an email from a stranger, and they say, hey, can you look at this case? And so I set up a formal phone call. They usually like it that way, and it's a mutual job interview. And you want to know, who's the lawyer? Do you get a handle that you can work with this person? What are the general facts of the case? How much work is involved? What do they expect from you? What's the time span? Because that's really important to me. Is you need something next week and you need a report. Well, no, sorry, I don't have time for that. I can't do that at the last minute like this. And then, as importantly as anything else, is whether I'm interested in the case, whether it touches me, whether it rings true or not. And keep in mind that the lawyer, you may talk with this lawyer and they may not want you, but we can get into that some more later. All right, and now I can't get this slide to move. Gosh darn it. Okay. Well, that worked. I don't know what worked, but okay. So, and decide if you want to do defense cases, plaintiff cases, or either one. I know of a site medical director in a mid to large county jail who doesn't take any defense cases. He just got tired of defending people for bad care, and he'll only look at good plaintiff cases. Me, I find good, interesting cases and good people to work with on either side of an argument. And frequently I'll call a person who I'm working on for a defense case, and I'll on the second call, and I'll say, boy, we've got a problem here. I would take this case as if you were the plaintiff's attorney. So, but decide, and you may need to just say, I'll do either one and just take what comes for a little while and then work it out. I think credibility is improved if you end up being deposed or in trial by taking plaintiff or defense cases. And I like the variety. Anything on that one, Isaac? I think it helps with credibility. But
yeah, it's very important from a presentation standpoint, and I'll get a little bit more into that when we get into the credential side of it, but I think that it is very important.
So we spent a lot of time on cases. I think that people like that. So I'm not uncomfortable with that, but I'm going to have to race through some of this. Paradox is important because for most of these cases, it's going to be difficult, and you're going to need to embrace the paradox that there's an argument on either side. That's the nature of these cases. That's the nature of the law. So struggle with the ethics. If you're doing a proper job, that you're going to be struggling with the ethics of the case, because most of these cases have two sides to them. I found that both those cases that I discussed were easy cases for me to take because I didn't think there was a good argument on the opposite side. I thought I was on the right side, but you never know, I guess. So then there's a second call. So you have this first call, you decide you've got that you can work together, you decide you're interested in the case. And the second call, you've reviewed the documents that the lawyer has sent you, and you've got a phone call with that lawyer to discuss the theory of the case and where you come down on this. This is a key juncture, because this is your time to jump off. And I have jumped off frequently at this point in a case where it's like, no, this is not a good plaintiff case. And then give my reasons. And I always try to play the devil's advocate in these cases where I'm like looking at the case from the standpoint of the other lawyer and discussing the pros and so I'm going to discuss the pros and cons of his case with this lawyer that I'm speaking with. For example, in a plaintiff's case, it's going to cost this lawyer a bundle of money to prosecute the case. And they should want to hear if it's a poor case. And if they don't want to hear that, that's another good reason to jump off, because they're asking you not to be honest. They're not liking your honesty. And so if you don't like the theory of the case and your lawyer is trying to twist your arm to like the case, maybe you should find a different case to be working on. And it is at this point where you can say, well, no, now that I've reviewed the case, I'm not interested in working on it. But I mean, that raises all kinds of difficulties. We're not quitters, we docs, but we need to be able to jump off if the case isn't right medically, clinically, ethically. And so
Mike, can I add something on that?
yes, please. And yeah, we'll get on to more of that. Yeah.
Yeah, and one of the things is when Mike says we want to know if we have a bad case, that is the truth. I mean, that is actually significant both for a plaintiff side and a defense side. And one of the things that can really, really damage the relationship and the reputation in the expert witness realm of things is some experts take cases that they don't really believe in, that they're almost willing to sort of give an opinion over the phone because they know it'll allow them to bill some time to review some records. But when it comes time to sign their name on a report by that opinion or say it in a sworn deposition, they start to get antsy and they start to suddenly not feel so confident in their position. And that is a massive disservice to everybody. I mean, the lawyers, the litigants, and ultimately the doctor. Any lawyer who genuinely cares about his client wants the unabashed truth from the very beginning. And, we are not, good lawyers anyway, are not looking for people to tell them what they want to hear. They want to hear as close to the truth as you can give them.
So cognitive dissonance is a talk all by itself, but people can do weird things when they're feeling under pressure. So for example, your cult leader says the end of the world is tomorrow and it doesn't happen. Well, then you could change your mind and think, well, but that means because I've been a good person that the end of the world didn't happen. The same thing could have happened in case one. Suppose you discovered the contract says the doctor in question is in charge of all training and it was the nurse practitioner or somebody who'd messed up. You're invested in this case now. What do you do next? And the answer is have a conversation with the lawyer. I discovered this. It's a real problem for your case, and be honest about it. And most of the time, these kind of things don't come up because a good lawyer is going to know about this document long ahead, from before. But once in a while, they're still doing discovery and something else pops up, And so anyway, and so your professional honesty is the most important thing. Be professional and truthful. Your opinions are not for hire. You are not a prostitute to the lawyer's opinions, and be careful about that. And I've had physician colleagues and friends who say I can't do that because these lawyers try and get me to say what they think I should say, and I'm not willing to argue with them. And it's like, well, no, you're right. If you're going to argue with them, and they can't listen to your negative judgments about their case, then run away. And if you can't run away, then do something else with your time. But so Isaac is here because he's honest and because I like working with him, because I trust him. And I had a more than a small handful of lawyers that I could have chosen to have talk here. And he's going to tell us a little bit about what legal experts in corrections seek in a good expert witness, one of the objectives.
Thanks so much, Mike. So here's the 4 points that we're going to be talking about. But before we do, I just want to make a pitch briefly that if you are not involved in this work, please consider doing it. And I'm not even biased in a side here. I am a plaintiff's attorney now, but I was a defense attorney before this. And I believe just as strongly in the defense work I was doing. Mike knows we worked a lot of late nights on a couple defense cases. And on the defense side, you know, this is a high volume litigation practice area for medical professionals. They get sued all the time, and 99% of those suits are baseless. And they need people who are available, who care about protecting individuals doing this very difficult and challenging work. And on the plaintiff side, there's a shortage of experts sometimes for the very reason I talked about, which is hesitancy to criticize the efforts of another physician. And so there's a real need in both sides, and I believe both sides are critical to the protection of all the interests in place. So please consider it if you're not doing it already. So here's the points we're going to talk about. So let's talk first about credentials, what lawyers look for credential-wise in selecting a expert for correctional medicine cases. Go ahead, next slide, please.
It won't advance. I don't know what happens on my computer, but I'll make it advance. Don't worry. Go ahead and speak. And
okay, so you know, basically, you could probably fill in the gaps. Here we go. This is a list of what the typical credentials that lawyers look at in selecting expert witnesses of any discipline, products liability, medical malpractice, you name it. This is what, you know, sort of the laundry list of things we look at. Now, what makes corrections a little unique is the weight that these items receive vis-a-vis other areas of litigation, even just pure medical malpractice in a non-correctional context. So for example, in normal medical malpractice cases, there is usually a high premium put on academic credentials, where you went to school, what honors you received. If, you know, a lot of times, if you're teaching at a learning hospital and things like that, those tend to be very highly prioritized expert witnesses. That is not the case in correctional medicine. Although obviously we do look at where you went to medical school or whether you received any honors. This is largely an experientially driven analysis for us. And the reason is because correctional medicine is so different in the dynamics. So, you know, although we look at all of these things, experience really gets the hardest and closest look. And I'll give you some examples of things that I look at, for example, when I'm assessing a CV, trying to see if I can use this expert and whether I think this expert is going to have a continuing relationship in our cases. So for example, I'm looking at, do they have experience in adult corrections and juvie? Do they have experience with private entities and public entities? Those are two very different things depending on the dynamics at play. Have they worked in jails and prisons? Have they been site medical directors, and have they also held regional medical director positions or patient safety officer positions? Because a lot of times in corrections, there's heavy policy elements at play. A lot of correctional medicine is facilitated through written policies and procedures and nurse pathways and things like that. And so having this higher level institutional supervision also plays a huge part in sort of the experiential analysis. We look at geographical nuances. Has your experience allowed you to work in multiple jurisdictions so you can understand how the standard of care might fluctuate depending on the jurisdiction you're in? And those are all things that are very, very unique to corrections. Not to mention, how your understanding of the security side of corrections, that often plays a huge part in these cases too, because if you don't understand the security side, you can give a standard of care opinion that doesn't hold up because it doesn't jive with the security policies at the facility that the case is at. So with respect to publications and speaking engagements, your instinct might be to think that the more of those you have, the better. And in some way, that's true. There is a certain wow factor when you're putting a witness up before a jury to say, oh, you have this many peer-reviewed articles, you have this many speaking engagements. But that also is a double-edged sword in that every speaking engagement and every publication that you write is a possible point of contradiction that someone can use against you later in a case. And that's something we have to think about as lawyers. Have you done something in the past that, someone can cross-examine you and undo your opinion by basically making you look that you're contradicting yourself for payment? That's a very quick way for a jury to dismiss an expert's opinion. Now let's talk about credibility. So lawyers, we begin a case and we end a case with the goal in mind of how do I win my trial? That is always the driving mechanic through which the decisions we are making, how we're making them. And a huge part of that for expert witnesses is their credibility. Juries are incredibly variable on the things that they will fixate on. And just to give you an example, we had a case once that we thought was a very strong case. We took it to trial. It ended up being a defense verdict. And we were stunned. We couldn't believe it. We thought our expert had outperformed the defense's expert. We thought that the sympathies were on our side. Well, the foreperson contacted us later and said, yeah, we were kind of with you, but then we heard that the defense's expert had been on Oprah before, and that just sold everybody. So there's some unpredictability in terms of what they will actually find persuasive, but generally having a good demeanor, it goes a long way. The jury research says that is always something the jury looks at. Watching you, do you strike them as honest? Do you have a personality? You don't have to be Mr. Popular, but you do have to have a personality that speaks authenticity. That is more of the important quality. Also, whether your demeanor allows you to stay cool under pressure. A lot of times, because experts can feel that lawyers are challenging them in their own field of expertise, which that's exactly what's happening, where things get under pressure, the witness can become argumentative, and that can alienate the jury. So that is a huge component of things that we're trying to assess when we're speaking with you and trying to learn about you. Another component of that is your history. And basically, what we're looking at is, are there risks that there's something in your history that is going to undermine your credibility before the jury? Some examples of that are your division of labor. So Mike was talking earlier about the apportionment of plaintiff and defense cases. And one of the things that, although experts tend to kind of lump on one side or the other, what can look very bad for an expert is if they are all one and none of the other. That makes it very hard to convince the jury that just every case is, they're honestly looking at it and they just happen to fall on the defense side or the plaintiff side. Another thing that we try to assess is, are there going to be any ways that they can assert that there's improper influences over your opinion? So for example, say the care at issue in the facility is consistent with the NCCHC standard on point, and you're an NCCHC surveyor, is there going to be some way that the plaintiff can say, well, you would never contradict this care because your relationship with the NCCHC imperils your ability to do that. So you're just going to say, you know, anything that goes with the standard is fine. We try to assess whether things like that exist. And finally, is there an existing relationship between the expert witness and either the party or the attorney that creates a specter of bias? You know, for example, is there are there friendships? Are there active financial relationships? You know, are you on the payroll of this, you know, whoever's been named as a defendant, if it's a corporation? And another big one that people often don't think about, but that comes up more than you would appreciate, is are you a competitor? You know, in the private sector of corrections, there's a handful of entities that sort of do most of the work, and having an expert work at a competitor can be a problem for that reason. Oh, Mike, we lost the slide for a second. There we go. And then similarly, you know, there's other elements of your professional history that can possibly be stains on your credibility, whether you've had judgments taken against you in malpractice suits or you've been subject to disciplinary actions. You know, if the defendant is a former employer and you parted under, say, less than amicable circumstances, that can be, you know, things that we look at. And finally, you know, whether you have any major criminal history, felonies or crimes that cast doubt on your honesty, like tax fraud or things like that. Next slide, please.
Yeah, I'm having trouble.
So the next thing, I'm going to keep going. It'll eventually
Yeah,
catch up.
please do.
How are we doing on time? Okay.
We are doing poorly. We've got 10 minutes for questions and we're at that 10-minute mark.
All right.
And I'm having trouble. My system is not working for advancing the slides, and I've been tricking it all along, but this time I can't seem to trick it. So I'm going to stop sharing and try something else. So why don't we stop questions now, and then Isaac, we can finish up once I can figure out what's wrong with my computer.
Okay.
And so go on ahead. Are there any questions up to now? None? We always get questions.
Well, that I can actually finish. I actually know what I was going to say. So it, you know, even if we can't get the slide up, I can just finish the final points. So the third thing we're looking for is compatibility, meaning, you know, does your schedule make you sufficiently available for the needs of litigation? You know, a lot of times there are, you know, we have, you know, if we bring you into a case, we need to be able to hop on the phone with you or email you and get your perspective on something before we go into a deposition. We're also in the same vein looking for flexibility because litigation very much is a fluid process, and there can be last minute changes and all sorts of crises that we're responding to in real time that we need to get you informed of and find out how it affects your opinions, if at all. Finally, attention to detail. You know, these cases often involve hundreds, if not thousands of pages of medical records. And there's just nothing worse than having your expert in a deposition and someone draws their attention to a fact they didn't read in a medical record, and it just completely breaks down their opinion. And finally, just trust. You know, can we trust each other to stay in our lanes, and can we trust each other to do what we're supposed to do and to stand, you know, in your case, stand by your opinions, and for me to not try and push my perspectives on you. And finally, with respect to cost, all I'll say with cost is, believe it or not, cost is the least of our concerns. I mean, you know, what we really want is we want quality experts, and, you know, lawyers are willing to pay well for that, you know. And so the only point I'll make is, you can charge a premium rate and not hurt your relationship or your reputation amongst lawyers. But if it ever appears that you're padding the bill, that's one that's hard to recover from. So charge a good rate if you want to make sure you make a good living on the case, but don't ever inflate the hours that it takes you to do something, because that can be very damaging.
So the first thing they always ask for when you're talking to a lawyer is a fee schedule and a CV. And if you've learned anything from Isaac about what he's looking for, the CV is essential, and that's the first thing they're going to ask for. But the second thing is undoubtedly the fee schedule. I have one I can share. I can tell you right now that my general fee for my work is $400 an hour, and I consider myself, I think I'm under market. And bottom line is I'm making more than I need to make, and I'm happy with it. So, but if you want to take a look at it, the first thing that I did when I was beginning to get into this work was a dear friend who's since deceased told me, here's my fee schedule. And I took a look at it, and I just more or less incorporated it, stole it. And I'm glad to have you steal mine. And I always have a basic agreement with the lawyer and the firm he works for, and I think it's important, and I can share one with you if you want. And but I'm not a lawyer, and I've never even had a lawyer look at my agreement. But basically, it says we work together until we're not working together, and that's the most important thing in my agreement, is that I can jump off whenever I want. And I think that most of us would like to be able to do that if there's a problem. You have to have a good reason. I mean, the lawyers have a big investment in you, and you can't just jump off for no good reason. But I've certainly had points where I needed to get out of a case, and usually it's after that second phone call. And then how do you get cases? I always get asked about this, and almost all of my cases come from word of mouth, and people know me. And the bottom line is, get to know somebody like me who's doing this work, but is getting out of it and has more offers for work than he knows what to do with, he or she knows what to do with. The ACCP website has a site for listing yourself as an expert witness. Headhunters, the lawyers tear you apart on that. I've only taken one of those cases, and I didn't like it. And part of it was because the headhunter was interposed between you and the lawyer. So finding someone who has too many offers for legal work and getting your feet wet with relatively easy cases are the way to go.
Mike, we have a question in the chat, and I think this is a great question. How important is report writing ability to the expert witness work? So what are your thoughts on that?
Yeah, I have a redacted report, and I stole that from a colleague too. And I essentially, the format for my reports are always the same, and writing is a key element to the job, but not for every case, obviously. Testimony is a key element to the job, but I've never been called on to testify. Like the one case back in 2014, when I was called and I appeared at the courtroom, and they settled while I was sitting in the courtroom. And so I never testified in a courtroom. And so that's 10 years of either awesome luck or careful case selection, or I don't know what else. But the bottom line is that's the case. So you don't always have to report, but writing is a key element to this. And I think that we can easily learn how to write a good report. And I will tell you this, I learned early on that it's not my responsibility to write all of my report. They're mostly interested in my opinions, and that they're well done and cogently put together. And so nowadays I go to the lawyer and I say, do you have a paralegal that can write up the timeline? Because I spent 5 extra hours of work on the last case I did writing up a timeline. And if you can pay somebody $50 an hour, then you're not going to be paying me $400 an hour to write up a timeline. And that was very time consuming for me. So I can still say and I go over the timeline, make sure I can live with it, but I can still say that I wrote the report. We getting some comments now, and I want to go to that.
And
Is there
just
a
as,
role?
oh, go ahead.
There's definitely, we have one about a forensic psychologist, and I think there's definitely a role. Can you respond to that, Isaac?
Yeah. So I'm a forensic psychologist who testify in court, often answer specific. Is there a role to play for a psychologist? Yeah, absolutely. I mean, there's a significant market for that. And I'll tell you, one of the emerging markets that I actually think is the analysis as it relates to and this may not be forensic psychology, but there's a lot of questions about when someone has suffered cognitive injury, how can we discern whether or not they're still having some sort of pain and suffering, being that they're no longer communicative, and differentiating that's a huge element. And another element of this work that could possibly relate to is where you have someone that's died in a facility, and the course that led up to their death was one that you would expect to involve some fair amount of mental and emotional suffering. Being able to reconstruct what the expected course of that would be, that's also a huge element of what we do. And then Catherine asked, are there proceedings where your credentials as an expert can be challenged? And the answer is yes. In both state court and federal court, there's proceedings where parties can challenge whether there are sufficient credentials of the opposing expert to testify. Typically, however, the threshold for credentials is relatively low. I mean, you have to have graduated, from the appropriate school in your discipline, and usually be a licensed practitioner. But the courts don't get into weighing whether they're good enough in the sense of high quality enough. It's looking at very, very basic level type things.
I've had my credentials questioned, and my credentials are fabulous, but I'm not seeing patients anymore. And it was based on the fact that I'm not seeing any patients anymore. I do a lot of clinical work. I review other people's work. And it's not just, legal work is probably under 25% of what I do, but nevertheless, it was challenged whether I could clinically, make comments about clinical care, because I haven't been seeing patients for 4 years now. And so we were all sort of taken aback by that, only because it came up late in the trial, but I think that was all strategy on the other lawyer's part. And I still haven't heard back on that, honestly. So yes, a loud yes. We're at time, and I hate going over on these. We're at 2:29, and if we get off by 2:30, then I will have kept my promise to keep these at an hour or less. I hope this has been useful, that people have learned something.